small and tight. Do not let you. Sarah's laugh rings through the night. Such a brute, drunk and silly, thought she'd play. Crazy witch, locked me in just for the day. Life's a bitch. Can't you hear me, Sarah, please? Broke ass bitch. Out of there, my lungs they squeeze. Let me out, you witch. This is not a funny joke. You put your hands around my throat. Feeling trapped and nearly choke. Gonna croak. Can't you hear me, Sarah, please? Broke ass bitch. Out of there, my lungs they squeeze. Let me out, you witch. This is not a funny joke. You put your hands around my throat. Feeling trapped and nearly choke. Gonna croak. Sarah, let me out, I'm begging, please. We can stop, I'm almost begging, please someone don't leave me here. Lost my hair, in this case I disappear. Are you there? Dark and tight, I curl and wait. Are you passed out? You'd return my fate. You emptied my stash out. The game has turned to cruel. Why are you filming late? Inside I feel the fool. I can't breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as her castaway. Sarah, let me out, I'm begging, please. We can stop, I'm almost begging, please. Pray someone don't leave me here. Lost my hair, in this case I disappear. Are you there? Boone! Looking tight, I curl and wait. Are you passed out? Hoping you return my fate. Empty my stash out. Stupid game has turned to cruel. Why are you feeling me? Lost it, I feel the fool. I can breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. Breathing stuff, I'm almost begging. Please. Drink some rum, don't leave me here. Lost my air in this gear. In this case, I disappear. Are you there? Sarah.
Good evening, everybody. How are you tonight? Man, oh man, do we have a good one for you. Give me just a second. I gotta take care of a couple of things here on the backside because it looks like we've already got the fools showing up. Yeah, we'll touch on that a little bit here shortly because they think they're being slick and they think they're being smooth, but they just don't really know what they're doing. It's okay, everyone. I will take care of this because, well, we'll just increase it to just a little bit longer and you should see it come popping across right about there. Yeah, now they got to wait 20 minutes before they can type anything in. Oh, eyeballs, aren't you a special kind of character? But that's okay because, see, all of these have been tracked. Thank you. Oh yeah, pity the fools that want to play around. Yeah, oh yeah, we've got you. Oh man. It's interesting to me that they would take so long just to become a sub, just to say, oh, you don't like me. That's okay. I'm used to it. Idiots. Tools. Yeah, tools would be the best description of them. Useless tools. There we go. We've got, and I went in and redid this and enhanced it so we can watch this with very little editing on it. I got it taken care of today. Here we go. Yes. There was, I enhanced the audio a little bit, and I'll be releasing the full video of this later today. Should come popping up about 10 o'clock.
James
It's a
Owens on
drool
behalf
drool.
of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
She's just swearing herself, getting sworn in.
I do.
So I did watch part of this today.
Good morning.
It's
Can you
a
state your
pretty
full name
good,
and date of birth for the record for me?
pretty good one today.
10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Hey, how's it going, fly on the wall? How's it going? Good to see everyone. Good to see everyone. We got it. Good to see you, Roxanne, Heidi, T-Rux. Good to see you. Janice. Good stuff. Punching on that keyboard, just punching it. Let's see. He's going to get up here.
What was
and
pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper.
Elka.
We would move that into evidence as states 2 for the purposes of this hearing.
All right, we can
Any
speed
objection?
this up.
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection?
Oh, yeah.
All right, what was pre-marked as state C will be received without objection as states 3.
So Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I'll just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law.
Good to see you.
Or prior
Good
instances
to
of
see
violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm.
Yep.
We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire.
Morning, Toy. Good to see you.
Because we
I
understand
haven't seen you in a while.
that the defendant can like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection.
Thank you, Toy. Yes,
But what we are
definitely
asking
hit that like button.
from the court now, preliminarily,
Make you feel
is
good.
if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law
Gonna
that
turn
no,
the heat on.
because under her statements that she gave to the experts, there was no overt act taken
I
by the
can warn
decedent
you.
on that day. There was no
Just saying.
overt action. And that's what's required under the law to trigger her response of acting in self-defense.
And she's triggered.
There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony.
Oh, boy.
What her testimony is we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then
Hey,
eventually,
Nanny Goat, good to
it
see
comes
you.
to a point in time where they're sitting on the
Good to see
couch,
you.
and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes is nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt acts taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death.
They're showing
And
the
it's only
case.
when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent. And she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now
Whoa. So she hit him with a bat? Oh. Speaking. Just teasing you. Oh, I see how it is, Toy. Ah, yes. Yes. So hits him with a bat? And she described this? Oh, boy.
now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating
Yeah.
that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived,
Doesn't
according to her,
matter.
that he would die or face great bodily
So
harm.
harsh.
And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about
Yes.
any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that
Good to
is
see,
self-defense
man.
that's
Good.
recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in
Yes, I
limine
see
is,
you now.
hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
There you go.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure
Don't
so
be.
probably can save some time here.
Son, you shouldn't be confused coming into this. There should be no confusion. You should know your case right from the get-go. There should be no confusion. That's just bad attorneying right there.
My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that. And
Well, that's what they're requesting. Bat Duck with a $2 super chat. Thank you so much for that. And you know what that means?
Hello guys, it's Jovan, and you know what time it is? Disco time.
There you go. Thank you, Bad Duck. Awesome. Happy. Oh yeah, there's lots of happy things happening tonight. Oh, it's gonna get raunchy. It's gonna get raunchy later. Oof.
the opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument
Tammy. Good
today
to see
is
you.
from a evidence perspective. Concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it.
Right.
My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Oh yeah, let me go confer. I don't know because I came into this situation unprepared. Let me fix that camera. It seems just a little low. There we go. Maybe that'll fix it. Well, we'll fix it later. That's a little
Judge, if I
better.
could have you repeat that question.
Sure. So my understanding,
Yeah, the judge is pretty straightforward. This judge, he's no nonsense. So far, I've been pretty impressed with him. Bad Duck saw you last night. Not sure on Shizzy's room. Well, anti-pterodactyl, you probably see a lot of these same folks in various places when we all have fun. Yeah, our sensitive ducky, Bad Duck. Oh my gosh, this judge is going to let him have it. Oh, he is going to say.
well, let me ask, I'll have a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion? So if we were at trial right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify. We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step one under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that
Oh, this means he doesn't know. He's trying to avoid it. Oh boy, this is going to be a slap down as bad as camel toe.
her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have.
You are not going to be playing this shit with this judge. This judge is about to lay this down. This is not an argument you want to be having. I think Sarah should have stayed pro se. This guy is awful, isn't prepared, and has no idea what he's arguing. So far, he doesn't. This is one of the. It looks like 3 attorneys that are representing her. That's what it looks like. They're probably out of some law firm or something, but this is not the way you want to present to the judge, because basically he's saying, no, she's going to come in and she's going to present this as fact of battered spouse syndrome, and this is not going to work. You'll be on for a bit. However, I have to be up at 5:30 in the morning to get ready for an early morning physical therapy. Well, you have a wonderful morning. And what it is tonight isn't going to be a super long stream. I may be joining with the expert a little bit later on to do something completely not like this. So just keep your heads up. And this is, and then we're going to, once we get through this part, we're going to go back. We're going to watch some of the interviews that we didn't finish up last night, and those things. So there's a lot going on tonight. Besides that, so just know that this will not be a late night here tonight. Just getting through this trial portion of it is going to be pretty good.
If you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for.
You're not making a good argument, son.
And getting those signs with what they told in outside sources too. They are able to make a determination based on their training and experience.
So, but based on the Okendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
Yes, but this is the problem that I'm having here.
Okay.
Self-defense is a defense. It's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason.
Well, most people do, but there are cases that they don't realize that they have mental health issues. Sorry, I can't super chat you. My words were appropriate, and my words were appropriate. Your words were wonderful. You don't have to worry about super chatting me. The self-defense is a dumb road to take. What a joke. Oh, hey, Yamaha brother, good. Yeah, no, this her and what the judge is saying here to her, to this attorney, is you're not going to try to slip this one in on me. That's what he's saying. You're not slipping this one in where she can claim that she was committing self-defense, because if she's claiming self-defense, she has to take the stand and she has to give her side of the story, or else you're not going to get this stuff ahead of time. She's going to have to take the stand. She's going to have to set those. She's going to have to, her words are going to have to be out there claiming self-defense. And then once she does that, then you can bring in your experts. Then you can bring in all of these people. Until then, they're not allowed to talk about this. That's what he's basically saying to this guy. You're not going to slip it in where she never has to take the stand, because her own words are what's going to tear her down.
Reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pre-trial. The state's saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense. Has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't.
Son, you're rambling. Get to the point. You are just asking the same question that he asked you. Don't repeat the question back to the judge. The judge understands the question. You must not be it must not be sinking in between the gray matter there. It's not firing. All cylinders are not hitting there. Yeah, I like this judge too. The judge already asked you this. What would be the purpose of me? The only way that I'm going to allow her this person's testimony in is if Sarah Boone's going to be up there first. That's not a question.
Don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited, and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand.
No. He's making a pretrial ruling that they are not going to the only way that you're going to get this in. And the judge has made this very clear. He's made it very clear from the get-go. The only way that she's going to be able to come up with self-defense in anything, because there's a certain statute where they have to give a self-defense pleading on this. They have to give jury instruction. It's some statute. I don't know what the name of it is off the top of my head. I'm not an attorney, but she has not met that burden that you cannot do this in pretrial. You can't do this in pretrial. But if she's going to claim self-defense, she would have had to have been claiming self-defense from the get-go. She hasn't done that. And that right there is where the judge is going to throw him out on this. Hey, Auntie, how you doing? Sounds like a personal problem. Do you need some self-care with a bubble bath, candles, roses, and Kenny G? Oh, well, Kenny G? Oh, that, I mean, is she looking to like get romantic, or is she looking to, end herself? Because the only way that you'd be playing Kenny G is if you were just wanting to like put your head underwater for a long time. Oh God, that's horrible.
Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine.
No.
But as to the admissibility
not.
of the evidence, it has to start with Sarah Boone. A judgment can't be made, or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
No, it's not.
Any other argument, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog, and that bad dog bites, and that bad dog has bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Warner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams
Zach,
rule victim and ask the court to rule prior to trial, hey, if this is how the Williams rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
Right.
All right. Thank you.
Until they can bring it in.
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing.
Do not even go there. This judge was about to lay into him. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection. And the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is. That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition.
No,
as to the
that
reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase.
Really?
That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of.
So you're saying he's about to get out of the suitcase. So you hit him with a bat? And is that what you're saying? You're saying that you hit him with a bat? And then you start teasing him. Hey, how's it going? Aqualis! Wisnator! Good to see you, Kiwi. You got all of them. Yeah, those are all the ones I have in there currently. I need to make some more. No. That he's got this backwards.
Out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? Yeah. You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical.
But you brought this upon you. You locked him up inside a suitcase, and now you're going to say, well, if he got out, he was going to beat me up. Well, geez, woman, you locked him in a damn suitcase. Maybe he would have got out of the suitcase and called the police. You don't know. Oh, geez, man. Oh, yeah, she's nuts. I seen the video of her while he's begging for his life. Exactly. And this guy is overlooking all of that.
Evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023,
I'm with you on
2023
that,
WL
Roxanne.
3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling?
Well, and that right there is a very fair ruling. So he's not denying that she can't use battered spouse syndrome. Whether you like it or not, he's allowing her to make that case, but the only way that she's going to be able to do that is if she takes the stand and she can provide testimony as to why this was necessary, which leaves her open for the opportunity to them to tear down her entire testimony. And it's about to get even worse for her defense. Her defense is about to be sent reeling, like in the most maniacal way.
I'm sorry, the court's ruling, forgive me. Defense.
Meaning,
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
my concern is opening. Can it be mentioned in the?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with
all
regard
good,
to that
QB.
motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to revoke the ruling.
Okay.
They will win on one
Frustration
part of
applies
this.
to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
I can see.
Here it is. Here it comes. Here it comes. Catch
I
this.
believe there's some state witnesses.
Line
Catch
15. With
catch this, because this is going to be really important. Pay real close attention. This part here is one of the things I saw this morning. So this is really important.
that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
All right, now I'm gonna slow it down so you can hear exactly what they're saying. Here it goes.
I believe there's some state witnesses here. We would like to revoke the ruling.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
I can see.
You've got the state witnesses here, do you know?
She's allowed to be here to watch.
I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
Do you hear that? There's no state witnesses. So this person right back here isn't going to be a witness. She's just there to watch. That's what he said.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir.
He didn't like that. Oh, he didn't like that at all.
I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding
Yeah,
guilt
that's the female
are
detective.
generally inadmissible and must be
Detective Hottie.
redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay.
Oh, that was a screw up.
Eugene is 53 Southern 3rd, 1104. But law enforcement,
That's a mistake. He knows it too. He just realized
are
it.
entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant.
No, this attorney is not court appointed. This attorney is self-appointed. Yeah, Dipstick. He seems to do that a lot. Yeah, no, he is not court appointed. She got all of her court appointed attorneys left. They, for various reasons, some of them left because they had conflicts because of witnesses. Some of them were because they were in charge of things with George. They might have been arresting detective in George's case, or they might have represented George whenever he was going through, the court system, or they might have represented Sarah, or they might have represented one of the witnesses in this case. So a lot of attorneys had to decline being representative because they were conflicted out. I think there was 4 of those. Now she did have 3 court-appointed attorneys and another attorney that she had hired earlier on, and he left also. Let's put it that way, because she was difficult to work with. Now this attorney, she put out an ad on her pleading, and he jumped out of the woodwork. He's from Tallahassee, not from this area. He came in to represent her, and he is getting paid by the court to represent her. It's at a lot less expense that he would normally charge. but I think this attorney may have done that just to get a name for himself, which sounds really familiar, doesn't it? Sounds really, really damn familiar. So here we go.
And tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion, where the Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree with it.
Okay, well, the Jackson case speaks for itself. The court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court.
I guess just take a wild guess which way he's gonna rule on this. If I'm not mistaken, he's gonna rule for the defense.
Is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions?
Yeah, so the defense won right there. That's a big win for the defense. So basically, they're eliminating what his the best description would be an uttered statement that he made about her being the cause of his death. They're able to, they're going to have that part redacted. So that part of the interview, which you saw in the interview at the very end of the interview, where he mentions that she was the cause of his death. So that's going to just be removed, that portion of it. The rest of it will be able to stand on its own.
Questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Nice, Frank.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres
550
from two incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment.
True.
The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident.
Tammy.
But this incident,
this dead guy.
it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial.
That's very true. That's very true. So what he's basically saying is you've got 57 pages that can be summarized into a shorter version because there's two separate instances. The other 487 pages are they have a bunch of stuff like when nurses made their rounds, the medications that they gave them, every time that a doctor visited them, all of their notes, throughout the healing process of however long that took. So 487 pages is a lot of information, which they could have summarized it down into probably at the most 5 to 10 pages. I mean, at the most. So yeah, a lot of that stuff is unnecessary because it's just, I mean, how many nurses make their rounds? What, every hour or every 30 minutes or something like that? I don't know. I'm not a nurse, but imagine that each time that they make those rounds, you've got those in there. Those don't need to be in. They could summarize this down into much smaller, palatable bite for the jury.
Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and there's...
Don't matter.
I can't tell you how many
That's
pages
your problem. Sounds like your problem.
discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages.
Completely different, brother. Because that is his job. He has to turn all of that information over to you. Every single bit of it, he has to give to you. In and out. Nice. That's completely different. And the same thing with you. Sure, you're handing over all these medical records, but it's not necessary to use those in the court filings. Just like they don't use everything that they hand over to you in the court filings. They are obligated to give you all of the facts that they have. Every scintilla of information they have, completely different.
And that hasn't been narrowed down, but that was given to us. So that's something else we have to stop and go through. 500, over 500 pages.
That's on you.
And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down.
They've already introduced it.
Did y'all not have George Torres' medical records prior to me sending them to you?
No, we didn't.
All right, well, we took the deposition of Dr.
No, because they weren't necessary. Having George's medical records was not necessary to have. It's irrelevant for the state's case. Why would they have his medical records? That's just the most ridiculous, asinine thing this attorney has said. Num, slurp, slurp, slurp. There. What? Dang, Cynthia. I mean, I can understand being a little antsy there, but dang, girl, I'm not that hot tonight.
Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client, but a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves.
Oh, geez, dude, you're going to lose so bad on this. This is not a road you want to be going down on. They have to present every bit of evidence that they have. That is the law, you idiot. Did you ever not watch My Cousin Vinny? God, Lord.
Involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing
That's
that she
not the
relied
argument.
upon. A lot of that collateral evidence
arguing
doesn't
the
come
wrong
into. And it's going to be.
I need to jump into the breach here.
Yes.
I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence.
Yes.
So you have to establish relevance.
I agree.
Yes.
You have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages I think the state identified as that, what of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she.
Well, I'm not worried because you're a firefighter. You're a fire fairy. You can handle the heat, can't you, darling? You can handle the heat. That's why the slurping and.
She testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
Yes.
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay, I can't let you know today, Judge. I'll narrow it down, or we'll talk.
Sweet cheeks. The judge told you he's telling you you don't have time. That's not how it works. You are going to have to narrow. If you want this entered in, this is part of your pretrial. If you want this entered in, you have to narrow it down, and you have to have it done today. If you don't narrow it down, I'm not letting this crap in.
In the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every time.
In 2018?
2018?
I'm talking about the 2018 incident with regard to the plate glass
I have to
window.
look at the records, but there is other evidence
That's
in
your
those
job.
records that's going to be relevant after she testifies. That's when she gets beaten,
No.
when he gets really drunk, or that's when he does something.
This is not how it works. And the judge just told you this is not how it works. You have to have the evidence in before then, because the case, the state has to be able to rebut it. If you don't have the information in there, he's not going to let it in. Why is he so unprepared? Because he took this at the 11th hour of the case. That's why he's so unprepared. See, he did this big document dump, a big document dump on the prosecution, thinking that he could bind him up. Prosecutions had 4 years to get their shit together, and they've done very well at making their case, putting it together, having everything ready to go. And just like whenever they sat down in all of those hearings prior to this, they said, we're ready to move forward. We're ready to move forward. We're just waiting on Your Honor to the court. The court. We're here at the court's leisure. We cannot push this any faster. The judge finally, after years of this going on, has said, all right, we're done playing around. I'm setting it for trial, and we're done playing this game. He came in at the 11th hour and is moved himself into this case. A little bit like Brucey in a sense, where he offered his services to her as an attorney. Nothing wrong with that. You're able to do that. She requested an attorney. One took her up on it. So he's coming in 11th hour. He doesn't have a good case, and this is pretty much a losing case. Point 3 is getting close to struggling with gravity. Yeah, that is. But this is you have to have this relevance in your. Basically, he wants it summed down into something that is not overwhelming the jury. Can you imagine if you're a juror, someone walks in, you've got 2 weeks to read through 500 pages. 2 weeks to read through 500 pages, and it's not reasonable. It's too much information. It's not good. That's what the state's case is. This guy needs to whittle that down. He needs to whittle it down pretty damn quick. He did it for YouTube cred and conjugal visits, I guess. I don't know.
Something violent or threatens to do something violent when he gets really drunk.
Doesn't matter.
In one of those incidences, he was
Doesn't
over
matter.
a point 3. When he gets over a point 2 to point 3, that's when he gets angry. He's fine up until that point. We're going to
Doesn't
establish that. I don't want to put on my defense today, but Judge, there is going to be relevant.
You have to show what your defense is going to be. They don't want surprises. This is idiot. This is idiocy right here. The judge, if he lets us through, I'll be surprised.
That's to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what
No.
about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. It's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction,
Have to do with
surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's.
No, and no. That is not how it works. God, this judge. If I was this judge, I would be going. That's not how it works, son. You need to come in here a little with something better than this.
It's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge.
Yeah, you do.
She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
No.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony.
No, you should know exactly what her testimony is going to be. If you don't know what her testimony is going to be, then judge should have no reason to bring this in at all, any of it. You should have sat down with those 500 pages that you got after you sent them to him You should have sat down and you should have had it briefed into a very small segment that was palatable and made sense of what your case was going to be. And he doesn't understand what his motion is. This is bad on him.
Testimony about how what happened to him was tied to what he did to her.
Okay.
How?
Anything else?
That's it.
Response.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense.
Yes.
The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. Ooh. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both,
I don't know,
the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here.
Yeah, because here's the thing. The prosecution, they gave him every single bit of evidence they had. And then they narrowed it down of this is how we are trying this case. These are the things that we're going to be using. You know, and it's like you've got, what is that, the 3 degrees to Kevin Bacon or something like that. You could have all these reasons, all of their research of, you know, we question this person made these statements. You're handing over all that evidence to the defense. But whenever you're sitting there saying, this is what our case is, and this is what we are going to be presenting, this is exactly what the prosecution said. We're going to be presenting this video. We're going to be presenting this video. We're going to be presenting these pictures. We're going to be presenting this PDF right here. Okay? They've narrowed it down to 160 pages. That's all the evidence that they're going to be using. Out of all the evidence they have, that's what they're going to be using. 160 pages. The rest of it, the defense has. So they have all of the information, and they're welcome to go and research all of that to see how they came up with this conclusion. Maybe they find something that was misstated. They can bring that information in. The defense already had these documents. They've had them since 2022. They've had these medical records. They had not handed them over to the prosecution. And when they hand them over to the prosecution, they haven't summed up as this is how we are going to use our case. They're coming in at the we're talking like they've got 15 minutes until go time. They're coming in saying, oh yeah, well, we don't know what it's going to be because we don't know what Sarah's testimony is going to be. If you don't know what your client's testimony is going to be, you should not be able to present that.
We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood. at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning.
Yep.
Thank you.
Thank you.
Yep.
All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident, the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. Yes. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right?
Yep.
Any clarification or questions with regard to the state's rule or the court's ruling? No, defense. No, sir. All right, thank you. That now takes us to
that got hammered.
The objections to the evidence.
Yeah, I wasn't happy to be alive. Guarantee it.
We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end.
And this is shenanigans that the attorney was playing. So what he's doing is he's sending him copies of what he's planning on sending with the clerk, but then he's not sending them to the clerk, or they're not getting file stamped or something. But it can be very confusing.
Is the notice of providing. it doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right.
Yep.
I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that.
No.
When it was filed. What was the next question?
No, he's asking. Okay, damn it. Let me explain. Whenever you file something, you're putting in a paragraph. You label it 1, 2, 3, 2A, 2B, doesn't matter, however you're doing it. Say, for example, you're saying that Shizzy looks hot tonight. Libel 1. And then you go to number 2 and, he does live streams. You go to number 3, he covers these objects, and then you have subsection A, B, and C. The court would the state would respond as to 1, we agree that this is true and proper. Number 2, they would agree that everything is true and proper. Number 3, and so on and so forth. They would either agree or disagree. They would put a response to it. All he did was just throw a bunch of garbage up on the court's website. He didn't label anything. He didn't identify anything. And that's what the judge is asking him. And he's confused as to, I don't understand. Like, what is wrong with this guy? No, he's flustered. Either he's flustered or he's incompetent. And I would say more than likely it's the latter.
Question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we
There's
intend
nothing
on
attached.
utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
I did cut out all the breaks on this, so it's going to run straight through. As you see, the whole thing is less than 2 hours.
Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48.
And if it's acting all jittery,
Advised
that
Jury
wasn't me.
Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around.
Yeah, stay away from North Florida courts.
The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here.
Nice.
That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines.
Response.
I don't know the layout of 23 site.
Can you all approach just for a second? All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well.
Kind of vicious
If it doesn't have
tonight.
COVID,
Ooh,
then I don't
scary,
have a motion
Tim.
for cause.
Okay. Any response from the defense?
Oh, the jittering is just crazy.
Correct. That is correct.
Anything in addition to how she was filmed?
I read you what was provided to me.
Yep. In other words, get your head out of your ass, defense.
Okay. Court's going to be in a 15-minute recess. Thank you.
See, 15-minute recess over.
We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State,
If Catch on behalf of the state,
William J. for the state.
defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can you all approach? All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, you can get appearances.
if Catch on behalf of the state,
William J. for the state.
Defense. All right, thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of the defendant's fifth amended exhibit list was e-filed on October 3rd. The fifth list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
And Judge, this was a
Crazy.
little bit of a,
I got to pause something for a second. Hold on. Okay. So it's in the recording itself. There's a little bit of jitter in there. You were raised on a farm and with a family and a lot of military vets. I took karate classes and in the neighbor's backyard. What does someone expect? That's true. Now I want to smoke. Coffee time. Coffee time. Ooh, I would love to have a little bit of coffee right now. Mega's back up and running. No strike. Only a 7-day ban. Yeah, he released the video. Yeah. It was more than likely it wasn't him that released it. More than likely it was YouTube that released it because there was no copyright infringement on that. Yeah, that's great news and thank you definitely for the update, Starzy, because that right there was a bunch of BS. And they're that little group there is looking for problems, and I don't think anybody should be harassing them whatsoever. None of that should be happening. People shouldn't be harassed on YouTube at all. For these people that want to come in and they decide it's all fun and games to come in and start harassing this channel, just know that you're being dealt with.
new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that.
No, that's not how this works. They've already introduced all the evidence they're going to use. They messed with the wrong people. That's what I told them. Breaking news, too. Within 5 minutes, too, the plant was really angry at it. Sorry to interrupt. No, absolutely. No, thank you for the update. And that's a big kudos to Megan. That was that's not how it should be. You know, it doesn't derail it. It's very pertinent because those kinds of actions affect all channels, not just mine, not just hers, not just Tug's, but it will affect the Toothless crew also. Whenever these things are done like that, it affects everybody's channels, because if you are making false copyright claims on channels, that affects all of YouTube. There's a reason why YouTube does not tolerate these kinds of things. That's all I'm saying. There's a big reason YouTube does not tolerate it. If he released it, that was good on him, but I don't think it was him. I think that it was more than likely YouTube stepping in and saying that's not appropriate. There's no penalty for false. Yes, there is. Yes, there is a penalty. If you're doing false flagging, you can lose your channel. You can lose your channel if you're false flagging people.
That time, something might make something relevant at a certain time, or it might not make it relevant. So there, and also as to just the foundational stuff, because the images, if I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photographs.
Foundation was laid.
Is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Ruh-roh. Ballstorm's here. Everyone behave. Good to see you, Ballstorm. Oh, we're on the X. Oh, yeah. No, he's here. Yes, I heard, Cynthia. I did hear.
Is this going to be considered a separate hearing for the record? Should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
Uh-oh.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal.
Boy, getting
Count up
handed.
as 147 photographs and videos. There is metadata that comes with all those files.
Yes.
So There is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this.
I'm going to pause for a second. I got to check something. All right, I see it now. Cool.
For the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will receive without objection as states 4.
Close to 100. I hope you are, Volstorm. I hope you're doing
So
better.
just to give the court an example.
So I was initially going to have this video released out today at 10, but I found that something happened whenever it was recording that is on my side that's making it all choppy. So what I'm going to do is I'm going to switch this thing over to the actual trial portion of this, just so it'll smooth it out a little bit. It's because there's some issues with it, so it's going to back up just a little bit with this guy because the choppiness is really getting to me. So give me just a second while I do this, because this is going to be doing this to make sure that it comes out just right, so I don't have to worry about that choppiness in there. And I've got to put my overlay in, so give me just a second to get that taken care of. That should take care of it right there. All right, and I'm gonna switch this thing over to this side here so we can watch it without all the jitteriness to it.
Not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay?
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
You just noticed the poop emoji? Yeah.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of the PDF case-in-chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108.
We'll skip forward a little bit.
That comes with all those files. 6/2019 context line of as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will receive without objection as states 4.
So just to give the court an example.
Come on, get with it there.
On page 49 of 59 of the PDF labeled Case in Chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The one
There it is. Listen. Poop emojis covering something you can't show. Correct.
that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019.
Christmas of 2019. Diane G with the 5 memberships. Oh my gosh. That is so wonderful. I will hit that thing like crazy. This is for all you 5 new members, and we are going to read those guys off here. Looks like Magic Angel was gifted a membership. Taz was gifted a membership. Cindy Brown was gifted a membership. Lily Smith and Musa Lady Wise Oracle was gifted a membership. And thank you so much for supporting the channel. Thank you so much. That is very, very kind of you. Diane G. It is so wonderful to invite all those fine folks in and invite them to come back for more. Love the dog. Yeah, the puppy's awesome.
And it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children.
Nice.
It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as like the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the 2nd District Court of Appeal, decided in 2021.
Oh,
Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal, decided in 2018.
2018.
Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well in 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations.
Well, keep an eye out. I know that I did speak with the expert a little bit earlier. He may be on. He's not sure. He had some things he needed to take care of. We do have a life outside of YouTube, and he had life outside of YouTube that had to be handled. So he wasn't sure if he was going to be streaming, but if he does, I will make sure that you guys are informed, and we will resume with him. If not, he may just end up jumping out over here, but just keep an eye out. Just keep an eye out. We'll see. You'll know when it's time.
That at some point, the decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone.
Oh.
We believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of
the damn it, Volstorm. If you don't know how to work that thing, you just you gotta learn how to work it. And what does he say?
One eternity later.
Who's laughing now?
That's pretty false term. If you don't know how to work that thing by now, so what are you doing?
The conversations and tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay, and it's not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I can't respond to you, I'm working. Those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections
that angers
before
him.
we swear in the
He's
jury.
mad.
So that the state can pull any photographs or videos, or we can have at least a discussion about those specifics, and then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but
there you go.
We're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
He didn't like that. So he basically, this guy right here threw out a blanket thing. We just want to have everything thrown out because there's things in there we can't verify. He's saying everything we have can be verified. If not, it may not be being proved for a fact. It's just to give context. Oh, they're pissed right now because they're hoping to get those videos thrown out. That's what they're hoping to do.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity, that these are just boilerplate objections?
Oh, boom. That's that right there. The judge just slapped him right there, just right across the ass. It was like, all right, if you're going to make objections, you have to make objections on those particular items. Like you can go back and say item 1A of this bait stamp of this part of this particular page on this particular document, image, 2. We object because it doesn't have a timestamp. You have to, whenever you're making these objections, you can't just throw out a blanket objection. You have to be very specific about each and every part of it that you don't, one of those items that the state is putting in there, you have to object on every single one of those. I'm not even an attorney, and I can tell you that. God, yeah, he's a knucklehead.
To all photographs, all video.
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. Correct. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't.
What? Son, are you confused? Did you realize you've got 15 minutes to go time? Man, this guy wouldn't make it like 10 seconds in the real world. I am telling you, this is stupid. Well, I just don't know what objection it would be. Because I don't know what the relevance would be. Then you did not read what they put out. because they've laid their whole case out for you. I don't think he slapped his bum. I think he kicked him in the nuts. Yeah, at this point, he just dead. And hell, Volstorm just dawned. Look at that. Look at that. Look at that. Nothing like having a soulless ginger here. Good to see you. Oh my gosh. Yeah. Did he just say speculation? Yeah, he just did.
Don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place.
So if you don't know how it's relevant to the case, then object to it. That's what you do. For relevance. Object to it for relevance. Fight them on every single one of these things, but you have to do it individually. You can't just throw a blanket out there and say, I object to everything. You're going to lose on this because you spent more time at Chuck E. Cheese at the all you can eat buffet than studying what their case in chief was, because according to the prosecution, all of our case in chief is laid out here and how each one of these tie in. You just didn't read it. You didn't pay any attention to it. You are a horrible attorney at this point. Sorry, but not sorry.
Between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation?
Well, no, you have to object to it ahead of time. If you don't see the relevance, object to it. Not hard. But you didn't do that.
To get it in, it's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is at that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase. We didn't object to those. Do you know why?
You just did.
Quick. I know when it was.
You just objected to it because you said you object to every single video, every single piece of picture, every single document. You objected to all of them. You just said that. What a Lloyd. Good
and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
then object to those.
It sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All means all.
The suitcase video is listed in in the things that we don't object to.
I don't know that. I have image _0954. I don't know what that is. Image _0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary.
What are you saying? You don't know how to file things for a court? That's why are you here? Why are you sitting here purporting to be an attorney if you don't know rules of evidence? Good Lord, it came from another live stream to say, huge thanks to whomever gifted your membership. Welcome, Cindy. Sorry. I believe that was Diane that did that. Give me just a second and I will take a look. You were gifted most likely by Diane G. She was the one that gave you that, and it is wonderful, Cindy. And thank you, and you can just thank Miss Diane G. She's wonderful. He's attracted to drama. Yes, this guy is attached to it like at the hip. Oh yes.
Preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted.
They conceded they need to lay the appropriate foundation.
Well-
Well, part of their argument.
Okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything
All
else?
of it?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do.
Son, the rules of evidence don't change from state to state. Rules of evidence are usually pretty well founded on how you present evidence and how you object. And if you're saying that it's different in one courtroom than another, I'll tell you it's the same way here in Georgia. You also had a lot of sugar when I don't usually eat much. Oh, this is so funny when I heard this. Yes. This is insane.
Do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then you all parachuted in on August the 30th.
Yes.
Yep.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the
Yep.
reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I deem to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As the foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant
right.
and not repetitive.
Judge, at this
So
point in
true.
time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an
Yes,
objection to it
exactly.
at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Janella Wadden. And then Janella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah, 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 with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint, for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection, relevancy, or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I
Yep.
previously identified. You can raise your objections at trial if you deem necessary. But based on the
Yes.
state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They're not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so.
Not today. I didn't play no
Any questions,
guitar
sir?
today.
Now, I just want to add something for the record.
Yes, sir.
The state doing its proper said there were no photos of the child. That's not correct. There are photos of the child.
Where? Where?
That are being sought into evidence.
Yes, Your Honor.
Which ones?
State? Response, if any?
Identify the photos. Identify these photos. He's looking, he's like, okay, if you say there are. He doesn't know of any. Is this guy part of the Harris campaign? He might as well be. I heard she got beat, smacked down. We're going to be covering that tomorrow morning, the smackdown on Fox News. If that's what happened. We'll see.
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
That's one of them. That's one of these are the prosecution. What you're seeing right now, that's the prosecution. That guy right there right here. This is one of Sarah Boone's attorneys. So this guy, and then there's another guy sitting behind them. But right there, that guy right there, he's an attorney for Sarah Boone. So there's 3 attorneys. This guy, and this guy are all her attorneys. I'm assuming they're all from the same one. Oh, I'm gonna love it. Oh, can't wait. Must have been rotten autocorrect. God, this girl's good. She's wearing a short skirt. Look at how short look at those legs right there. She is just coming in showing some leg, isn't she? Damn, girl. Is she even wearing pants? Yeah, now is the time to see which ones it is and which photographs need to be removed of the child. Must have been not autocorrect. I hope it's a dude. It's not. It's not. She does. It's not. I wouldn't say it's appropriate to court attire, but hey, So she's going to show where the items are, and he's going to pull up on the on his computer and confirm.
Okay, I see 2 images. I couldn't recognize it as a reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those 2. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the
There
picture,
you
so
go.
I'm at a loss.
That's fine.
Well,
I'm sorry, Judge.
extraordinary file name, but I'm going to remove those 2
Okay.
exhibits if there's.
I take care of that issue for you, sir.
That takes care of that issue, Judge. But the point
There
that
you go.
I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now.
You're
They
going to
can
lose
make a
on the
proffer.
argument.
I understand they can make a proffer, but they're proffering evidence. Once it goes up, the witness is in all, and the court has told me that I don't raise my
I don't wear
objection,
pants.
so I
So,
understand the court's ruling.
I want to see.
All right, thank you very much.
Just kidding.
Anything else with regard to the defendant's
I don't wear
objection to
pants,
state's
man.
digital
So what do you mean?
exhibit, Mr. Henderson?
Skirt? No skirt.
No, Your Honor.
Okay.
I was
Moving
just
now
admiring
to
the legs.
Defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed.
My biologist. No, I don't need to be to see a good set of legs.
It will
I don't
just
care
be
if it is a
dealing
dude.
with the-
Good set of legs.
Objections outlined. It is not lost on the court that it is 12:30.
Not saying I'd hit it. But
We do have a
just
jury
saying.
coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our
He's
panel?
not going to know because he didn't do
Or is
his
that
job
acceptable
right.
to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury
I
selection at that
understand.
time. I
You're
will
not in
keep
trouble.
you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all.
Bam. And the judge closes it out. He says, enough is enough is enough. We are moving forward with what we are supposed to be doing. So he's called it out. He's like, yeah. So the prosecution didn't get everything in that they wanted to. The defense didn't get all their objections that they wanted to, but they did preserve everything. So those were the hearings for today. Initially, I was going to release that video because it fixed a lot of the audio. And I would just have to go in and do a little bit of editing. So that should be out tomorrow morning. I'll have it released. Right now it's been set as a private video because I want to make sure that I get all those problems addressed with the sound. It'll probably be right after the little break that they had. Let me see, and I'll forward it to there so that way whenever everybody's pulling this thing up, they'll be able to find it, and I'll be able to find it there. So that right there concludes that portion of it. Man, it sucks. I thought I had it done good, but of course not. No, that would have been silly. That would have been silly to do that. And save. All right, so that's taken care of. So I don't have to worry about that popping out on me and coming out at 10 with messed up audio. That sucks whenever that happens. Oh, crazy stuff. So you have a great place that makes Korean fried chicken, all kinds here, and it's beautiful. Yeah, there's a couple of good places here in Atlanta that do those things also. But it's crazy enough to see that these folks have gotten so jacked up on their own garbage that they've lost sight of what this case is all about, what their defense should be. And let me see if I've got the let's see, it would have been the car interview, which is 18 minutes of car interview, and I've got probably about 15 minutes left of the husband's interview that I'm going to show. That was right. Was it? No, it's a little bit more than that. Let me see. I want to see. Yeah, that's what I've got. I was about 7 minutes into it, so I'm going to be playing that, and I'm going to be playing Sarah's interview in the automobile. These are two that I think are going to end up being pretty important, and want to make sure that we get those out of the way. So this is the ex-husband.
But I mean,
she started just getting really angry when she drank a lot. She said last night she fell asleep. There were plenty of times where she just basically passed out from drinking. So,
So you've witnessed her pass out from drinking?
Oh yeah.
Okay. And when she passes out, is she like out cold?
Oh, she's out.
Wow.
Like how difficult would it be to like wake her?
Well, I mean, if I were to like shake her or something,
Right.
I could probably wake her up. But me making a phone call or noise probably wouldn't do it.
Okay.
Ooh. That's pretty wasted.
And would she be like in the middle of doing something and just like out cold, or would she
No,
like go to bed
Yeah,
and
it would
just be out cold?
Yeah, she wouldn't like fall over or anything. It'd be more of a lay down and then she's just out.
Right. Okay. What
I
do you
think this is an awesome
know
picture.
about her and George's relationship, if anything?
It was. I mean, I think she had him arrested like 5 or 6 times for domestic violence. I mean, he's
Pick up the
stuck
speed
a
on
steak
this.
knife in the back of her leg one time.
Okay.
Whoa.
He's been so has he always been the one
So he stuck a steak knife in the back of her leg one time? Ouch.
that gets arrested, or is she ever?
She
get
was
arrested?
also one of the times.
Okay.
One of the times, both of them were arrested. But all the others have been him. But the very next day, she's in there trying to get bailed out. So
Right.
I don't know. Basically, they get drunk, they get in a fight, she gets
She's
upset,
got
she
a
calls the
problem.
cops. I mean, granted, I saw lots of black eyes, bruises.
On her?
Oh, yeah. Yeah. So, I mean, there definitely was. Now,
Would you see George as much as you would see him or her?
I hardly
or
ever saw him.
You hardly.
I honestly, I didn't like being around either one of them,
Right.
to be honest, and him more so. So, why's that? Just, I don't know. It's my ex-wife. She made me really mad with everything. How the whole divorce went down, and just, I mean, the way
Yeah,
she
she
acted,
caught
the way
you.
she changed, and the way they both are, I mean, what it's done to Lucas and everything else, he's nobody I cared to see. Let me put it that way. I mean, it's not like I really went out of my way to, like, it just...
When you guys do drop-offs or anything, is it always through the school, or would you like have to come here and see them, or no?
No, it's pretty much always during the school. Now, sometimes she would come over or something like that. Sometimes he would be driving, but I mean, he would just stay in the car. She would come in. So, I mean, I really wouldn't see him.
So it's not like you have like conversations with George. Okay.
No, I mean, maybe a few times when they drunkenly called me at night because she was telling me she needed to escape because whatever's going on, or she's put him on the phone, but I don't know.
When's like the last incident that you recall of there being like a domestic dispute between her and George?
I recall.
I mean, she told me like a week ago she had to escape from the house and wanted me to come pick her up. I told her I wasn't going to because I'm just tired of it happening. I mean, it was midnight. I mean, child's trying to sleep, and just honestly, I don't always believe her when she said these things were going on. And
She called you?
Yeah.
Okay.
Yeah, and I mean, apparently she went back inside and slept well. Was in a fine mood the next day. I guess didn't really remember calling me, so I don't know if it was
Was it
just
brought up again?
if it was just hey, she wanted to come over to. I don't know. She keeps on trying to come over to like hang out or something like that, or she'll come over to spend time with Lucas rather than actually just having him over here like she's supposed to. But she wants to come over there and play with him. And so I'm not sure. I realized last time I know there was an actual physical confrontation. It's probably been a little while because this last time George got arrested, I know he was on free trial, whatever, something. I don't know. He had a parole officer. He had a domestic violence class. He's like.
So that's the last time. Basically, the last time he was arrested was the last physical altercation that you recall.
I think so.
Okay.
I don't know for sure, but I think so.
And you have any idea what year or month that may have been?
Like a few months maybe.
A few months ago.
Yeah, something like that maybe. I don't think it was
She
incredibly long.
shook George's hand and says,
around the
"Thank
holidays
you."
of last
And
year,
forget
before
where
the
you
holidays?
found her.
I think it was
She's all
probably before
yours.
the holidays.
Yes.
I'm trying to remember.
Okay.
That's right.
Because oddly enough, there was like a 3-week period where she actually had Lucas all the
And I'm like, heck no, you shouldn't let your son over to drunk fight house. No, you shouldn't. No, not at
time she was
all.
supposed to because he was in jail for a month or something like that.
Okay.
Because they wouldn't let him out.
Yeah.
Yeah, because he's. Yeah.
And you said when she drinks that she can get physically aggressive.
She can. I mean, she did it to me a lot where she'd hit me and stuff like that. I mean, she's tiny. I
Yeah.
mean,
What do you mean hit though? Like open hand smack you, or like try and punch you?
Yeah, she'd punch me. I mean, more arms. She many times would use her claws. I mean, I had scratches on my neck at times, on my arms. I mean, things like that where she'd dig with her claws.
Okay.
I never got that drunk, and I had restraint. I never touched her back. I think George didn't have that restraint, and at times he would hurt her back. So I mean, for all I know, all the times he got arrested, she started it. I don't know. I wasn't there, so. But I know she could get violent at times.
No idea.
Okay.
But I mean, I don't know. It wasn't anything too much. I mean, just.
Right. Yeah. I mean, you don't feel like she was a huge threat. I'm assuming, right?
No.
Yeah. Like you could handle yourself.
Yes.
Does she drink daily?
I think pretty much.
Okay. Do you know like her drink of choice?
That would be vodka.
Vodka.
Or wine, but vodka is the big one.
And does she or George have a job?
No. She hasn't worked for over 2 years.
Wow.
Well, I guess you could maybe call when he's got a job. He worked at the Ace Hardware up across the street here,
Okay.
which is now going out of business.
Okay.
He kind of off and on worked there. When he did work, it was 15, 20 hours a week, something like that. I mean, my alimony and stuff basically pays for where they live. So, I mean, they didn't need a ton, but, I mean, she was always calling to borrow money. And but, yeah, it's been like 2 years since she got a job. She keeps on telling me she's looking. She's always finding other opportunities and everything, but...
I feel for him.
Okay.
Do you want to take it?
It's my dad. Just
Sure,
one second.
yeah.
Hey.
Crazy.
Well, just wait. I'm talking with the detectives right now, and I should be heading out here soon. So I can come get him, okay? Is John out? Oh, okay. Is he awake? Okay, good. Okay, well, I should be up there very soon. Okay, bye. Sorry.
Okay. We were just on the phone with someone. Okay. When you came over here, I know you said that she called you freaking out saying he was dead. Did she give you any more, like, just why or how?
She told me that they were playing last night or something, and he got in the suitcase and she fell asleep.
Okay.
That's all she told me, so I don't know anything beyond that.
Okay.
And I really didn't talk to her much because I came inside, I told her you need to call the police, and then I came back out, and I think she went on the back porch to smoke a cigarette, so I didn't really talk with her much.
Oh, like she was going outside. Did you see her take a cigarette?
Yeah, she was going outside with well, I also know when the cops showed up, she kept on telling them she had a cigarette burning out there and she needed to go put it out.
Okay.
But they were keeping her away from stuff, I guess.
Right. Okay.
But yeah, she wanted me to come back there with her. I was like, I'm going out here. I don't really want to be in here, so.
Right. And that's when she went to call 911?
Well, she called 911 while I was in there. I was standing right in the foyer area.
Okay.
And I mean, it was apparently a pretty quick conversation, and that's when she started to go that way, and I just told her I'm going out front, so.
Okay. Okay, so they were playing, and she went upstairs and went to bed.
I don't know
After
where she went. She just told me she went to
Or
sleep.
she went to sleep. Okay, you don't know where.
I don't know where.
You can ask more questions.
I didn't ask more questions.
I don't know what bed she fell into. You're awake now and adrenaline.
Hey, I'll let you know when I'm done talking to these guys, okay?
Yeah, they were leeching off of him. That's what it sounds like.
That's okay. All right, never mind. Okay, bye. I'll call you when I'm leaving.
That's what the court order says. That's what the court order
I haven't really
says.
been over here lately.
So it's been a long time.
It's probably been at least weeks, maybe.
Does Lucas play baseball or anything yet?
We've tried to get him into sports. He's not a big sport.
Christine, they haven't done the opening statements yet because they haven't completed jury selection. They'll be completing jury selection. I believe they completed that this afternoon. And tomorrow they probably will have a brief. And we'll see what happens in the morning. But no jury selection yet. They haven't gotten there. So no worries. You were number 69. 69.
Sports person, really.
Did you ever play baseball?
He didn't play baseball. Well, I mean, I had like a t-ball set and stuff like that, and we'd play catch.
Was it like plastic t-ball sets, or what kind of equipment did you have?
Oh, no, this is when he was like 3 years old. It was a little plastic thing I had in the backyard.
Did you ever buy him any baseball bats or anything?
I bought one for over here that Sarah said for Lucas and George to like play with or something. That was like a year ago or something, maybe.
What kind of bat was it? Was it a wood
They're
bat?
about the
Yes,
same
it was a wooden
size.
bat. Like I think it's like a junior size thingy. I don't know. It's something that looked like kind of for his
Something
height
that
or
George
something.
can
I think.
handle.
All right. Sorry.
Would you mind if I took a picture of your call log to show
Sure.
that you've all the
You just want to see
attempts?
hers, or like zoomed in on hers so you can see all those?
Yeah, that's
Okay.
perfect. So I'd say starting from today. I know her phone.
Did you text with her at all today?
Not today. I don't think I did today at all.
Sorry.
That was last night. She was drunkenly texting me.
Last night?
Yeah.
What time?
That was 11 o'clock at night. I think that was
Last night was Sunday. Was it Sunday?
Oh, that's Saturday. Never mind.
Saturday.
That was Saturday night when I was watching the baseball game.
Okay.
Yesterday, which is that, she said her account was in the negative, so I transferred her a little bit of money to get her out of the negative.
Wow.
That was the morning. Okay, so she thanked you at 11:56 that morning.
Yeah.
Right. Okay. What's the last thank you? What time? Okay, so just a few
Yeah, and
times.
then that one at
What a
12:01
nice
on-
guy.
Okay, so afternoon, Sunday afternoon.
Yeah.
Okay.
That he does that for
And
an
then
ex-wife that's a
calls.
piece of garbage, just so his son can
Do you need,
you
like-
know,
Yeah,
have
I'm gonna.
food.
Yep, I'll start from the top where it has her information.
Man,
Go ahead. You can scroll down. No,
Okay.
still he's I mean he's still a bit of a
Thank you very
gook,
much.
but hey, you know, it's bad.
Okay. Has Lucas ever told you anything about her, like witnessing anything between her and George?
He's heard
How can that
arguments
be
and things like that.
Dang.
He's not a big fan of staying over here, honestly.
Okay.
Just because they get in arguments and stuff like that. I don't think they've ever had a physical fight in front of him.
Okay.
But I know there's been arguments he's told me about.
Okay.
There's been times where I think things were starting to get to that point, and she has called me to come pick him up
Okay.
and bring him back over to my house. So
Yeah. Okay.
she's generally pretty good about having me come get
Yeah,
him.
he is an enabler.
Which leads to me not having a wife because I can't ever do anything.
Right.
So I can't go anywhere because I'm too worried about something happening and me having to be over here quickly.
Yeah.
Dude,
Okay. Do you have anything else?
Yeah, do you know if she's ever had any issues with drugs in the past?
To my knowledge, she's never really been a drug person. She's big on alcohol, but I don't think she's ever done. I mean, I think she told me like one time, like back before we got divorced, that at I don't know, this bar thing over there across the street near the Walgreens, whatever it's called.
Okay.
I don't remember, but somebody gave her a little bit of cocaine, like 2 years ago or something like that. I've never known her to do drugs.
What about George?
No clue whatsoever.
She's never complained to you.
No. That's not to say these things don't happen.
man, I'm sorry, dude. And I'll say what really ticks me off about this guy is that he doesn't know anything about this George character, okay, at all, and he's got no problem sending his kid over there. No problem whatsoever. Yeah, I'll be sending people over there after we're done here. But he's got no problem sending his kids over to this person he knows nothing of. He's never met the guy. And I will say my brother-in-law, he's got 2 kids. Well, his current wife. Well, there's only one wife. His wife was married before. Went through a bad divorce, abusive guy, and he has partial custody of, well, he did. They're over 18 now, so he has no more custody or obligations or anything like that. But whenever they were married, he made it a point to meet the guy. My brother-in-law did, just to say, hey, you know, this is who I am. Because I want you to know that your kids are safe around me, that they're not going to run into any problems. If you run into any issues or you think something's going on, you know, this is my phone number. Feel free to call me and we can have a discussion. The guy is still a bit of an ass, but you know, my brother-in-law was, you know, that kind of person. It was just like, you know, because he's thinking, you know, I'm going to have kids at some point in time, and I want to make sure that if they're in this kind of situation, that I know the person that they're going to be around, the person is going to be taking care of my kid or is going to be involved in my kid's life. And I mean, that's the normal thing to do, and this guy's just completely oblivious. No wonder she's all screwed up drinking around and screwing everybody else.
Try to keep myself out of and away from them in general, but
Right.
It's not how you do, man.
the Prius right up here. Yeah.
Oh, that figures drives a Prius.
That is what I got sent. I know it looks like a vanity thing. No, that's just this last time they, I guess, sent me a new plate and that's what was on it.
Awesome. So you can make it up whatever you want it to do.
I could.
Tell them it's for racing. You're going to.
Yeah, I think you're racing.
Yes, racing in my Prius.
I'm not saying you win. I'm just saying you race.
Oh, man.
Yes.
Okay. Anything else, Scott?
Well, he does, but he still should know who this guy is that's around the kids. He doesn't have to allow the kids around, and that can also be something that you can bring up in a custody thing. I mean, there's ways to do this, or you could ask it, you know, what it wants or needs. Yeah. Jeez, what a.
Okay. Is there anything else that you think is important for us to know that we have not asked you about either George or Sarah?
I don't think so.
I mean, you guys have been separated for, what do you say, 5?
We've been divorced about a year and a half. We were separated a good 8 months before that or so. And we'd been separated one other time before that, before we got back together, and we're trying to do therapy, which didn't work at all. So how long has she been living?
Imagine that.
Ever since we got divorced. So a year and a half ago? No, longer than that then. Because I took over the house. I moved there and she moved here. Because I told her I was buying her out of the house. So I guess it has been longer than that. I think she just said she renewed, so maybe just past 2 years. That may be right.
I think she said she's been here like 4 years.
No, she's been with George. I don't remember what she said.
She was with George before we were divorced. So.
Yeah. Okay.
God.
And any time that that you recall when you guys were together, and she would be drunk, did she always like resort to getting angry? Like, is she an angry drunk, or would she, like?
Her main problem is she can't stop.
Okay.
I mean, she can't go out and have a glass of wine with dinner.
Right.
That's not anything she can do, because when she starts drinking, she'll continue drinking basically until she out. Yeah.
If she were to be drunk, would she like want to play games with you? Like, did you guys?
Yeah. There's a really good period where she is very good, but then she drinks past that and she gets into the angry bits.
Okay.
See, there it is.
Okay.
Just what they asked him. Does she get angry whenever she drinks?
Do you promise and swear everything we've talked about has been true and accurate to the best of your knowledge?
Yes.
All right.
Okay, this ends the recording 15:52 hours. And after looking through Sarah's call logs, I noticed that she called you on February 23rd, which would be the Sunday night at around 23:46 hours, and that's military time, but in normal time, that's 11:46 hours. Do you recall that phone call?
I do, well, somewhat. I was asleep when she called. So she woke me up. I was half asleep when I was talking to her. She did sound very inebriated.
Okay.
I don't remember what all I'm kind of used to her calling drunk late at night and things like that, so it didn't faze me as anything out of the ordinary. I basically just kind of got her off the phone and told her I'm going back to sleep and I'll talk to you tomorrow.
Okay.
Yeah.
You said that she sounded inebriated, like she was drunk?
He was demoralized before he got there.
It's hard. I was half asleep at the time. I don't think I remember hearing anything bad in the background or anything that would have caused me concern, but I don't really remember it that well.
Okay. But she was under the influence of alcohol based off of your knowledge of just knowing her and knowing when and when she's not under the influence.
Yeah. As soon as I heard her start talking, I almost kind of just zoned out away from it because she says all kinds of nonsense when she does this late at night, and I was trying to get her off the phone so I could go back to sleep. Yes, I'm sorry, I'm on the phone right now. You need to get yourself right off. Get yourself right off. Your pajamas are right here, okay? Hold on, buddy. I'm sorry.
It's
sorry,
okay.
go ahead.
It's okay. Oh, go ahead.
Sorry, go ahead.
Are you ready? Okay.
Yeah.
Okay. So, do you remember her saying anything specifically about George?
I don't think so. I don't really remember. I really don't remember much of the conversation, honestly.
Okay. I appreciate it. Okay. And the phone conversation lasted for a little over 2 minutes, if I'm not mistaken?
May have been, yeah.
Okay. And you said that is kind of normal for her to call you late at night or just kind of whenever she's under the influence and she's kind of just babbling on and you have to try and get her off the phone.
Yeah, it's a thing that happens.
Yeah, don't try to get her off, man. Not when she's been drinking.
Okay, so you can't remember anything specific
drunk.
about what she may or may not have said, but she did sound inebriated.
Ryan?
Does that sound correct?
Yeah.
And you couldn't hear anything in the background?
Not that.
As far as like arguing or yelling or anything like that, you couldn't hear any of that?
I don't think so.
Okay. Do you know where she was located? Did she ever say?
I was assuming she was at home.
Okay, but she didn't say.
I mean, she didn't have a lot of money. She didn't really go out anywhere, so I assumed she was at home.
Okay. But you wouldn't know where in the house she may have been?
No.
Okay, she didn't give you that information. Okay.
Not that I remember. It's possible she said something. I don't really remember, though.
Okay. All right, is there anything else that you think is important for me to know about that phone conversation?
I don't think so.
Do you guys talk often? Like, in a day's time? Like, do you guys talk daily?
More than I would like. Normally, anytime I'm calling her, it's to find out if she's actually going to be picking the child up like she's supposed to.
Right.
Like that next morning with me constantly calling.
Right.
She'll call to talk to Lucas, or sometimes when she's drunk, or she wants me to come pick her up because she's scared of George, or, any number of different things.
Okay, you're kind of like her call person, like she...
Yeah, it's gotten very old over the last couple of years, so I've started to just kind of ignore what she's saying and just try to get her gone as soon as possible.
Right.
I would have ignored
for a long
it.
time. I tried to help her out, give her refuge, get away from him, and she just kept bringing him back, and I eventually just gave up on the situation, so...
Right.
I would have given
All right,
up
do you
before
promise
it
and
even
swear
got
everything that we
there.
have talked about has been true and accurate to the best of your knowledge?
See, bye.
Okay, this ends the recording.
And yes, that was brought to you by Melly D. She does have a channel. I'll put the link in there. Hopefully before this thing ends tonight. And here's the car interview with Sarah.
It is February 24th, 2020. The time now is approximately 16:57 hours. This is in reference to Orange County case number 20-017904. I'm currently located in my unmarked vehicle out in front of 4748 France Lane, apartment number 3 in Winter Park, at the Tealwood Park Apartments. And also in the car with me is my partner.
Detective Scott Lowen.
And in the front seat is, can you state your name, ma'am?
Sarah Boone.
Okay, and your birthday?
10/10/77.
Okay. So, Sarah, I know you have talked to some deputies. I know we had a very brief conversation, just to reiterate what you told that deputy. But like I was explaining, I would like to get a more further understanding of what happened last night and ask you more detailed questions. I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that?
Yes.
Okay. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
Do you understand what I just read you?
Yes.
Okay. So last night you said that you and your boyfriend George were here at your residence and didn't really leave that day. You said that you
right
went to the
there
store to buy
is
cigarettes.
Yes.
What time was that around?
Her link.
If you recall.
Well,
Was it light
I
out
think
still?
it's
Dark
her
out?
Yes, it was light out still.
Still light out.
You
Okay.
do a search for that,
But
you'll
he's the only
find
person that
her.
left and he came back,
Yes.
I'm assuming.
That's who did this recording. So make sure you go check her out. Give her some subs. I think she's still under 500. So let's see if we can't get her up there. I mean, she took her time out to do this. Show her some love.
Okay.
It's right down the street.
It's down the street. Okay. And tell me what you guys were doing next. Like what was happening?
We had a bottle of wine. We painted, we drew, we did puzzles.
Do you remember what wine you guys were drinking?
It's Woodbridge Chardonnay.
Okay.
The bottles are in the trash.
Okay. Chardonnay.
Bottles.
Okay. And do you remember around like what time this was that you guys were sharing the bottle of wine, painting, doing puzzles?
I'm going to say 4-ish.
Okay. And was this before he went to the store or after?
4 in the
Had he already gotten
afternoon.
home from the store at this point to buy the cigarettes?
Yes.
Okay. So it was around 4 p.m.
Ish.
that you realized and you guys were
Wow.
doing.
Puzzles and art,
Okay.
listening to music, enjoying each other's company.
And all downstairs, upstairs? Where did you
Downstairs.
guys? Downstairs. Okay.
We usually sit on the back porch because we smoke. You're not allowed to smoke inside, so.
Okay. And who was here last night? Was it just the two of you?
Mhm.
Yeah. Okay. No one ever came over at any point?
No.
No. Okay.
We called his daughters on FaceTime.
Okay.
We were just literally just enjoying one another's company.
Okay. And you guys share the phone that you have,
Yes.
correct? Okay. And the phone's located in there, I think, in the
Yes.
kitchen area. Yeah. Okay. So tell me what happens next. So you're painting. You guys are doing this puzzle together. You obviously finished the bottle of wine.
Yes.
Did you have 1 or 2 bottles of wine?
Well, we had one previously that was maybe not even half full.
Okay.
But then,
So you finished that one and then you had the full one.
yes.
Okay.
Wow.
And sorry, what was the question?
What'd you guys do next after the bottle of wine? Like after you
Well,
guys
we
finished
had-
the wine?
We had the bottle of wine while we were
And they're
having,
just like
doing our arts and
midgets too.
crafts.
They're tiny little
And
things.
from there, we were puzzled out, we were painted out. So being silly, let's play hide and seek, which we had played before. Like, I don't know if you've opened the door on the top of the stairwell, like he and I have hidden in there before, like just having fun and enjoying each other's company.
Okay.
So, I mean, that's literally all it was. And then the suitcase is downstairs because I was telling you
bottle
we were
and a
giving to
half between
donations.
the two of
And
them.
because it's not a very good suitcase, what was the question? I'm sorry.
You were just explaining to me the night.
Oh, he decided to hide in there. So being silly, he and I mean, were sitting there laughing at it, like with him in there. And then, so I didn't zip it up all the way, but I mean enough to where his little fingers were out there and whatever, but still having a good time and whatever. Then I guess I decided to go upstairs and I don't know, I fell asleep. So
So you've heard that this is her testimony that she just decided to go upstairs and I guess she fell asleep. Doesn't say anything about striking him with a bat. Doesn't say anything about yelling at him. Doesn't say anything about recording him because she's blacked out drunk and has no idea what she's doing. Billy silly laughing at him and says, "Ha ha, there's Sarah. Ha ha."
woke up this morning and again thought he was downstairs on the laptop looking for a job, as he
Yes,
usually
she
is.
did.
And then thought, where is he? Is he on the back porch? Is he in the bathroom? Like, where is he? And then I came to about the suitcase. So I opened the suitcase I took him out, stretched him out, started to do CPR. Where air was coming out, and then like whatever gurgle. So I'm trying to do CPR on him. I'm shaking him, trying to get him to come to, but I could tell by looking at him, something was wrong. He's been losing his teeth lately and has been complaining about his chest hurts, which is why I keep trying to get him to go to the doctor, but because he nor I have a job or insurance, has been putting it off. So again, I didn't know what to do, so I called Brian, my ex-husband. I called him, he came over, just walked in and then walked out. I grabbed my phone and I called you guys.
The first time you woke up this morning, did you look at your phone just to see what time it was?
No. Most of the time, like, I'll wake up, but because he nor I have a job, I'll usually just lay in the bed for a little bit longer because the house is clean. There's nothing else that we can do. Me thinking he's on a laptop looking for jobs, I can't use a laptop. So most of the time, I'll just stay in the bed and collect my thoughts and get ready for the day.
So do you have any idea what time you woke up that first time? What time it may have been? I don't know if you guys have
I'm going to say 11 something. 11 something.
Okay.
Maybe.
Is that when you finally got up, or is that the first time you woke up?
No, that's the time that I decided to get up because I figured he was downstairs on a laptop. So let him look for jobs on a laptop, and then it usually I'll clean, he'll look for jobs, or vice versa, where I'll look for jobs and he'll clean.
Okay. So you think you got out of bed after 11 at some point?
Yes.
Okay. But we can't recall which time. Do you think you were up for like hours before that, or collecting your thoughts?
Brian, because I was supposed to have my son today to pick him up from school. Brian usually calls to make sure, hey, are you sure you're getting Lucas today? Because I've had job interviews.
Right.
Are you going to pick up Lucas? So after he called like maybe 3, 4 times, maybe 5, I finally answered, and that's like...
Do you think you were sleeping and missed those calls?
No, I ignored them.
You ignored them?
Because he's notorious for blowing up my phone.
Okay.
But I understand why, because he's making sure that Lucas gets home.
Right, yeah, okay.
And to do whatever he needs to do day-wise so he can schedule around it.
Were you upstairs in your room at that time when you were ignoring those phone calls?
Yes.
Yeah, okay. Okay, so we're not really sure what time you woke
Mama
up
don't care.
initially, but you were upstairs collecting your thoughts. You figured he was on the laptop downstairs, so you were just getting ready for your day.
Yes.
You finally got out of bed
you stay up
sometime
all
after
night
11
drinking.
a.m. And had gone downstairs.
No, that's the thing. It's not that they're staying up all night. They're drinking from sun up to sundown and well into the night. They're passing out. I mean, they have no decent sleep schedule. I don't know how people can do that. I really don't. Like, I mean, for me, I have a few drinks and I'm like good, and I take my happy ass to bed, you know. But getting like ripped, oh no. Had 2 shots of moonshine, I was gone. I drink 2 or 3 beers a year, but my little boy turned 30 and wanted to do a few shots with me. Hey, nothing wrong with that, Elka. There's nothing wrong at all with that. I mean, you know, her problem is she can't be around alcohol because she doesn't know when to stop. And there's people, most alcoholics that you run into that are serious alcoholics, they don't know when to stop. They get to that point and they just keep going and keep going and keep going until they just can't pick it up anymore and swallow any more alcohol or consume anymore. They drink till they pass out. You know, something's definitely wrong with that. Anxiety, city to not have somewhat of a sleep routine. Yeah.
Yes.
Okay.
Looking for him, and
couldn't find him. You looked outside, couldn't find him anywhere.
He wasn't in the bathroom. I was thinking maybe he's in the bathroom, but then I came to.
And then you
came to.
And then you called Brian.
Yes. He
told
came
him to come over.
Yes, he came over.
Lives down the road,
Yep.
right? Not very far.
Exactly.
He came over, walked in, basically walked out. You called 911.
Yes, I had my phone in my hand. I just wanted to wait for him to get there because I didn't know what to do.
Right. Okay.
Call
and then
911?
Like I couldn't. I don't know what happened. Like I don't know what happened, but like my whole thing is the whole like teeth losing thing, and I don't know what happened. Like I don't know what happened. I don't know what happened. He and I were having an amazing time yesterday, like we normally do.
No arguments.
No.
Nothing. Okay.
And the thing with him though is, which is why we've been doing puzzles and artwork lately, is that he's been stressing about a job, of course, which we've talked about. So what I did was start having him do puzzles and artwork to keep his mind off of it.
Okay.
His ex-wife is all over him about sending money, which he can't do because he doesn't have a job.
Right.
So he was stressing about that. He's been stressing about the job. But that's why I started to buy puzzles and paint to get his mind off of them, which is what I don't know if you noticed on the wall in there, it's all of our artwork and stuff.
Okay.
So I don't know. I mean, music, art, and playing with the dogs, dancing around the room with the dogs. And then decided to play hide and seek.
Interesting how her story
Because we're always
changed
trying to
to
outdo each other on
abusive
where we
relationship.
can hide the best.
How often do you guys play hide and seek?
Gosh, that was maybe what, third time? Maybe.
Okay. Is it a more recent game you've gotten into, or 3 times in total in your relationship you're talking about?
Lately.
Lately.
Because again, like we were puzzled out. We painted already, so why not?
So you were downstairs hanging out. Do you remember around what time you guys started playing hide and seek?
Honestly, I don't.
Do you remember if it was dark out?
It was dark.
Okay.
It was dark. But my thing is like when I spend time with him and I tried to get him to start doing it, I don't look at the clock.
Okay.
I'm here with him and we're having a good time. I don't need to know what time it is.
Right. I didn't know if you were like on your phone,
you're
if you got a
drunk,
text
lady.
message, if you got a phone call last night.
We called his daughters yesterday,
God.
FaceTime.
Right. What time was that at?
I don't know without looking at my phone.
Okay.
But I ended up,
Would that be the only activity that you had yesterday on your phone?
I called Lucas. I talked to Lucas. He's my son.
Okay.
I always
night?
call him.
Morning?
No, it was
And?
evening.
Evening? Okay.
But
I'm just trying to help you, like, remember, like, something you did right before hide and seek that would help you remember a time or give us a good time frame, because that's important for, us to know. You want to be able to tell the doctors that.
I don't know, to be honest with you.
Okay. So when you called when you called Lucas, was it before or after hide and seek?
Before.
Okay.
How many
And
bottles
when you
after
called
did
to
you-
FaceTime, his daughters before or after hide and seek?
Before.
Okay. And did you call the daughters first and then Lucas, or Lucas first and then the daughters?
I know I talked to Lucas, but then we talked to the daughters afterwards.
Okay. Okay.
And I don't remember if she called us. No, I know he called Cookie.
Thanks, Taz.
But yes, we called her.
What are the 2 daughters' names? Or just one? Did you say one
He
daughter?
has
or
3
two?
children. It's Anna, Cookie, what her real name is Destiny. And then he has a handicapped son, Georgie.
Okay. Who did you call though yesterday? Who did you call?
Cookie,
And what is Cookie's real name?
Destiny.
Does she have his last name or something else?
It's Torres. Because she remarried, but I don't know her last name.
Okay. Okay, so you know it's dark out, but you're not really sure what time it is. You play hide and seek. How long do you guys play hide and seek before he decides to get into the
Go to
suitcase?
sleep. I hope you get some sleep, Taz.
Approximate.
Wasn't really. I hid upstairs in the shower.
Mm-hmm.
And then came downstairs because I was tired of hanging out in the shower.
Okay.
So that's when he was playing around in the suitcase. So
Okay.
because we both thought it was funny that,
Yeah.
oh yeah, well, I'm going to zip you up.
That,
Uh-huh.
I'm
You
with
didn't
you
come
on
look for
that,
me.
Auntie.
So again, it's a broken suitcase, but
What do you mean by broken?
it's only got one of these. But because I
Oh.
didn't zip it up all the way, he was doing the
You mean it doesn't have like the pull part?
correct.
Okay, but it's
No,
got,
I think it's got a, what do you call it? A paper clip.
okay. So the zipper to it is missing, like the actual zipper that attaches to it to help you open and close is missing, but you think a paper clip was on it instead?
I believe there's a paper clip on it because I know that the last
That's
time.
what you used to like help assist you?
Well, or you can just stick your fingers in there and
Right, yeah, you could
unzip
do
it yourself, which is why I did not zip it up all the way.
Okay. So how much did you zip it up?
I mean, I don't really know.
You said his fingers were able to stick out?
Yeah, two fingers.
Okay.
Yeah, so I'm figuring he'll get it. He'll get it. But then I wanted to go upstairs and waited for him, and eventually I guess I fell asleep. I had the dogs in the bed with me, was warm, and then fell asleep.
Wow.
So you guys are joking. He's in there. You said you could see 2 of his fingers?
Yes.
And then, like, you just decided, okay, I'm going to go upstairs now? Or?
Because I figured he would get out and then go upstairs and have intimate relations like we normally do. But I fell asleep.
Okay.
And he never came upstairs. So, again.
Oh, not that she was afraid that he would come upstairs and beat the snot out of her for locking him in the suitcase. That's not what she's saying here.
And I'm thinking he's downstairs on the laptop earlier today.
Okay.
And then remembered.
Okay. So is this something that do you guys play
Remembered.
hide and seek before you have sexual intercourse, or do you guys just play hide and seek because you're bored and you're just trying to pass time and it's fun?
We were again puzzled out. Can't paint anymore. Even started to purge some of the art that's on the wall now. So
Wow. Yeah, that interview cut off at the very end, unfortunately. That's all we've got. We may hear more later on. Maybe we'll see. That is absolutely crazy. Well, I am going to be sending you guys over to see the expert. He's doing some coin pushing tonight. He's watching some coin pushing. I'll probably join him for a little bit. I will see you guys over there. Everyone have a wonderful night, and make sure you hit the like and subscribe on the way out. Tomorrow morning, we're going to be talking about some interesting interview with Camel Toe, plus a bunch of other news. Yeah, she has it there. Bump uglies. The mental visions are looking into the Ark of the Covenant. Good night. I'll see you in the morning, everyone. You will see me over an expert here shortly. Have a wonderful night. See you soon. Peace, y'all.
Look inside, I call and wait. You passed out, hoping you return my fate. And you must stash out. Stupid game has turned too cruel. Are you feeling me? Love is gotta feel the fool like you breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, begging, please. And please, breathing stuff, I'm almost pegging. Please, please, don't leave me here. Lost my air in this year. In this case, I disappear.